Okay, I think we will get started as we do have a very robust discussion planned for this afternoon. Thank you all so much for braving the torrential downpour down outside. We're very happy that you all are here for this discussion today on the Geneva Conventions at 75 and the future of international humanitarian law. Hopefully you're all in the right room. And today we're going to be talking about the adoption of the 4 Geneva Conventions of 1949, which was a watershed moment. And of course, in the aftermath of World War II, states came together to pursue the common goal of protecting persons not taking part in hostilities during conflict. So we are celebrating the 75th anniversary of the Geneva Conventions this year, but we're also at the same time witnessing an explosion of international and non-international armed conflicts, from Ethiopia to Russia and Ukraine to Israel and Palestine. And we've also noted that the circumstances of conflict are changing. So we see an increase in non-state armed groups, the private military and security companies, and of course mercenaries participating in conflict, as well as the involvement of sub-regional coalitions. Climate change has also had the potential to spark new conflict, and the current and future use of artificial intelligence is giving rise to new frontiers on the battlefield. So there are myriad challenges around humanitarian access and assistance, a need to demystify the rules and their applicability to today's armed conflict situations, while also ensuring that they continue to be relevant and sufficient for addressing current and future challenges. So this panel will bring together experts to discuss these issues and also what comes next for IHL. I'm going to start with some introductions. To my immediate left, to your immediate left is Lieutenant Colonel Ron Alcala, who has served as a JAG in the U.S. Army and is currently a law professor and associate dean at West Point Military Academy. He also serves as the executive director of West Point's Press and executive editor of Articles of War. He's also the co-editor of The Impact of Emergency Technologies on the Law of Armed Conflict and is an executive committee member of AISL's Liber Society. I should also note the bios for all of our speakers are currently listed in the app, so I'm not going to read out everyone's full bio because then we would be here for much longer than what we have allocated today. So please do check out the full bios on the app. Then we have Lakmini, who is an operational legal advisor at the International Committee of the Red Cross, who is currently serving as the legal advisor and head of the legal department at the ICRC regional delegation for the United States and Canada. And she's previously worked in Sri Lanka, Afghanistan, Iraq, and Syria. In her work with the ICRC, Lakmini engages with states, non-state actors, and their influencers to implement and operationalize IHL. We then have, my order is a little up here. I'll next introduce Tedes at the very far end, who is a postdoctoral researcher at the University of Geneva on the platform for international water law at the Geneva Water Hub. And he has previously served as a teaching assistant at the Geneva Academy of International Humanitarian Law and Human Rights, and as a lecturer in law and research and technology, interchange director at a university in Ethiopia. And finally, we've got Afonso, who is an assistant professor at the St. Louis University Law School and a member of the editorial board of the Journal of Humanitarian Legal Studies. And after finishing his PhD in IHL, Afonso joined the University of Oxford Institute for Ethics, Law, and Armed Conflict, and has also been a Jesuit priest since 2010. So today's conversation, we really wanted to make it more of a conversation as opposed to a series of just presentations. So I'm going to ask each of our panelists a couple of questions and have a bit of a dialogue amongst the panel before we open it up for questions at the end, and I will be extremely strict on time. So think of your questions, no statement please, but questions for our panelists at the very end. So Lakmini, I'm going to start with you. Coming from the ICRC, which we all know, of course, has a very special role with the Geneva Conventions and the holders and keepers of doctrinal IHL. As 2024 is the 75th anniversary of the adoption of the Geneva Conventions, how would you describe the significance of the conventions and their implementation in the last 75 years? And what would you say are its major implications for the way we fight wars today?
Thank you, Christy, and pleasure to be here. Thank you all. So in the interest of time, I'll try to be brief, but there's tons to be said about what you just asked, but maybe starting off by saying Indeed, it's the 75th anniversary of the Geneva Conventions of 1949, but we also have to remind ourselves there's the first Geneva Conventions of 1864, and we're celebrating 160 years since then. So the journey has been long, and the commitment to regulate conduct in armed conflicts has been a conviction that states pursued since 160 years at least in terms of treaty codification. So that's one good thing to think about. And then, of course, when you think about the 1949 Geneva Conventions, one could say that it was a product of its time, because it was essentially responding to consequences, the horrendous consequences of World War II. And in that sense, there were circumstances. It was a response to circumstances that prevailed at the time. And also, one can also think of the fact that there may have been powers that were more influential in putting those the conventions together and sort of spearheading that process. But at the end of it, the resulting agreement was very significant, whatever those circumstances that led to it. And a few things to note in that is that there was agreement about the object and purpose of these 4 Geneva Conventions, and the object and purpose being to minimize suffering in times of armed conflict. So that's an agreement that everybody around the world, the states around the world that sat together agreed on. And then the second thing is, in light of that, to try and minimize the suffering through a balance between military necessity and humanity. And the second principle that we see throughout this agreement is the fact that reciprocity does not apply. Parties to conflict, be they states or non-state actors, are bound by these rules. And therefore, the commitment is towards all parties to armed conflict. And to that end, the conventions focus predominantly on international armed conflict. And we can also say that large-scale military operations are not a thing of the recent history. It's something that was already the case in World War II. So this was responding to large-scale military operations. It didn't forget non-international armed conflict. There's at least one provision with minimum standards that must apply in times of non-international armed conflict. And it laid down ways in which those who are not and no longer taking part in hostilities should be protected. And it created mechanisms through which there could be a neutral intermediary during armed conflict. There could be protecting powers in times of armed conflict. There could be instances in which it paved the way for accountability, because there's a grave breaches regime in these conventions. So there's a lot to say about the framework that was put together. And then came the agreement behind it, how states the process of ratification. So by now, we know that there is a global consensus, because there's universalization of the Geneva Conventions. There are 196 states that are states parties to the Geneva Conventions. And it's interesting to note some interesting facts about this is that, of course, the conventions came into being on the 21st of October 1950, came into effect when Switzerland and Yugoslavia ratified. But already in the 50s, there were additional 74 states that ratified, another 48 in the 60s. And each time states ratified these conventions, they ratified it as a set. No one chose to do the first one and not the third one. It was always as a set. So it shows the conviction that states had when accepting these treaties and ratifying them. And even when you look at national implementation of these treaties, there could be improvement for sure. There's room for improvement. But at the same time, there's a whole series of military manuals that have incorporated these principles. There's integration into doctrines. There's laws that have been incorporated the principles in local legislation. So the global consensus in accepting the preventive value of the Geneva Conventions is not something that we should take lightly, I think.
You've mentioned, of course, the universality of adoption of the Geneva Conventions. As far as I understand, it's still the only universally ratified treaty body in the world. But of course, there are some challenges with implementation. And as the ICRC works not only with states and militaries, observing and discussing some of these major trends that have come up in the last few decades, and of course, the ICRC releases its challenges reports every few years, looking at some of these trends and of course, the challenges. What would you say are some of the noteworthy trends in contemporary warfare and the challenges posed by the development of new means of contemporary warfare, and of course, in the methods of warfare as well? Maybe from a humanitarian perspective, would you say that there's ever a question around the adequacy of the Geneva Conventions to ensure humanity in war?
So I think we have to start off by going back to a question about the implication. The main implication of the Geneva Conventions today is that whatever shape or form an armed conflict takes place, there is a framework in place to regulate it. We have states around the world and non-state actors have to accept this. There is a framework in place. And the challenge today is for us to build on that, to comply with that, and to build on that, and to surpass that, and not to question the framework as such. So in that spirit, I would say the ICRC looks at challenges not as issues that have not been foreseen at all, but as issues that have come up over time. How the newer manifestations of belligerent conduct and innovations in means and methods of warfare that require us to look at the frame, to apply the framework into and see, can they be regulated? Are there gaps? Are there ways in which to fill those gaps? So for us as the ICRC, we of course absolutely don't question the fact that IHL has to evolve. And it has to evolve. Why? Because it wants to keep to its promise of protecting those who are affected by armed conflict. And it has to do so in line with military, the evolution of military practices and military technologies, right? So the question is not whether it needs to happen, it's how it needs to happen. And I would say that draws us back to the object and purpose. What is the law there for? So in this sense, I think there are a number of things that we can talk about in terms of challenges, but in the interest of time, and I know Ron will go into detail of some of these, I'll mention a few. So there's the proliferation of non-state actors, as you talked about. I don't think that's the challenge. The challenge is how states and actors came about to regulate or to deal with the phenomenon of proliferation of non-state actors. We came up with CT frameworks. We came up with counterterrorism legislation. So how do you match IHL? How do you coexist IHL and CT frameworks? That was one challenge we had to look at. And then the fact that we have now new and emerging technologies. We have autonomous weapon systems. We have AI, use of AI in the battlefield. We have new domains of warfare. And military operations are now going into outer space. And Afonso will talk about this. And when you look at these new and emerging technologies and multi-domain military operations, again, if you look at the law, the basics are there. Wherever the conflict takes place, there is a way to classify whether it's an armed conflict or not. Common Article 1 talks about it. Common Article 3 talks about it. Then Article 36 to the Additional Protocol 1 talks about new means and methods of warfare and how to regulate that. So the framework is there. But as the ICRC, again, we would not question the need for evolution. You do need to spell out how autonomous weapons are being used. And we take the position that some autonomous weapons should even be prohibited because it takes away the human control and judgment in the process. And we do accept AI can serve a purpose. It can have potential benefits, but there are risks, and therefore AI has to be regulated as well in terms of international humanitarian law. And then again, if you look at the involvement of civilians in armed conflict, and when I say civilians, what I mean is private individuals and tech companies. Of course, these involvements, particularly private individuals being involved in armed conflict, is nothing new. We already saw this from decades back at the inception of the Geneva Conventions as well. But now, with the emergence of technology, the scope and scale and speed at which this is happening is evolving. So how does the law look at that, and how does law regulate that? Especially when states are encouraging these conduct with the use of apps, for example. And when tech companies take on cyber defense capabilities, what does that imply in terms of their protection as fundamentally civilian actors? Where do they lose protection? And the law does talk about direct participation in hostilities. So there is room for us to work on these issues, and the challenge is how. Now, I would say, beyond all of this, and there's of course information operations, and how that intersects with misinformation and disinformation. How do you regulate the conduct in that regard? And there are different ways in which we can talk about it. But I think fundamentally for the ICRC, we think there's also a more obvious challenge, and that is compliance. The law is there, the fundamental rules are there, and there is a problem of compliance in today's world. And that challenge is not just a challenge, it's an obligation. The law does impose or recognize obligations on the party. So I would say that is the most obvious and most important challenge and obligation to address today.
I was going to ask you, how do you recommend dealing with these challenges? But you did answer that question. So maybe I'll turn next to Ron, looking from more of a state and military perspective. As like Meany has described, various challenges such as climate change, the rise of non-state actors, the urbanization of warfare are influencing how contemporary armed conflicts are fought. And so from a U.S. military perspective, how has the law of targeting, in particular, in urban environments, changed in the last 75 years since the Geneva Conventions were adopted?
Thank you very much, Chrissy, for the question, and thank you to Jess Peak and the rest of the ACIL team for putting this panel together. Thank you. I should start with the standard disclaimer before I begin. The views expressed that I'm about to express are my own and do not necessarily reflect those of the United States Military Academy, the United States Army, the Department of Defense, or any other department or agency of the United States government. Okay, with all of that out of the way, for starters, I believe that the fundamental principles of the law of armed conflict remain adequate in contemporary warfare. So these principles, the principles of distinction, military necessity, proportionality, and unnecessary suffering are embedded in the Geneva Conventions and the additional protocols. That's not to say that targeting has gotten any easier, or that, for that matter, that targeting was ever easy. One topic that has gained a lot of interest in recent years deals with civilian harm and national policies designed to mitigate civilian harm in armed conflict. These policies include the Department of Defense's own recent instruction on civilian harm mitigation and response. Incidentally, this topic is the focus of a panel for tomorrow at 0900, so I'm not going to get into too much detail here. But as I think the panel is going to discuss, there is a tension between what is perceived as required by law and what is mandated as a matter of policy. Lieutenant General Chuck Peedy, who served as the Judge Advocate General of the Army from 2017 to 2021, talked about what he called a gap in understanding between what is required by the law of armed conflict and what has come to be expected in armed conflict, sometimes constrained by policy. It's essentially a lex lata versus lex ferenda debate based on military operations from the perspective of the military. He wrote an article which was called The 18th Gap, and in the article, General Peedy argued that 20 years of CT operations and COIN operations had created what he called a gap in the mindset and the expectations of commanders, of soldiers, as well as members of the general public. He wrote this. He wrote, "The popular misunderstanding of modern warfare imagines highly precise smart bombs winning the battle, if not the war." He went on to argue that this view of warfare would be highly detrimental in a conflict with a near-peer adversary. Large-scale military operations, large-scale combat operations, as like Meany mentioned, will involve much larger forces, so larger formations of infantry, larger formations of armor, more warplanes. So expecting that the same highly constrained and surgical employment of force in what we call a LSCO, large-scale combat operations, would, in his opinion, unnecessarily limit a commander's legal maneuver space on the battlefield. Ultimately, General Peedy argues that what is needed is, and I'm quoting from his article again, adherence to the law of war and its fundamental principles: military necessity, distinction, proportionality, humanity, and honor. Some of you may recall that honor was added as a principle to the DoD Law of War Manual back in 2015. So from a US military perspective, the law of targeting in an urban environment hasn't really changed. What has changed, however, are the capabilities of military forces, as well as the expectations of how combat in urban areas are expected to be conducted.
Thank you. Could you maybe talk a little bit more about some examples of how you believe that the application of IHL has been impacted by contemporary developments, particularly from a state perspective?
Sure, yeah. So there are a lot of interesting developments that occurred during the Ukraine conflict. And one example implicates the law of surrender. So in September of 2022, Ukraine introduced what was called the I Want to Live project. And this project was designed to encourage and enable Russian soldiers to surrender to Ukrainian forces. It did this by allowing Russian soldiers to contact Ukrainian forces either by phone, by website, or by messenger app to express a desire to surrender. Once contacted, Ukrainian forces would then arrange a specific time and place for a formal surrender. Now, one wrinkle, at least from a legal perspective, was the way that Ukrainian forces actually facilitated the surrender. In some cases, or actually in many cases, Ukrainian forces would use drones to monitor and accept the surrender of enemy soldiers. Now, a basic rule of the law of armed conflict provides that combatants placed hors de combat, or out of the fight, must not be made the object of attack. Those rendered hors de combat include prisoners of war, so POWs. They include individuals who are wounded or sick and out of the fight, and they also include individuals who have surrendered. Now, expressing an intent to surrender is not the same as actually surrendering. Traditionally, this wasn't much of a problem because the expression of an intent to surrender, either the laying down of arms or raising your hand over your head, took place relatively close in time and space to the actual surrender. With the I Want to Live project, on the other hand, the expression of an intent to surrender could take place days or even weeks before the physical actual surrender takes place. In the meantime, the surrendering soldier is not considered hors de combat, and therefore arguably remains targetable. Well, what if the surrendering soldier actually makes it to the prearranged surrender point, and the soldier is met not by other soldiers, but by a drone? When does his or her surrender actually become effective? Now, the DoD Law of War Manual states that to be effective, surrender must be 1, genuine, 2, it must be clear and unconditional, and 3, it must take place under circumstances where it is feasible for the opposing party to accept surrender. Now, assuming, for example, that the first 2 conditions are met, is it feasible to accept surrender by drone? Well, arguably, yes, it is, but the enemy surrender will be fact dependent. So, for example, is it feasible for a helicopter pilot who's flying overhead to accept the surrender of an enemy soldier? Or is it feasible for a fighter jet pilot, a pilot in, say, an F-22 Raptor who's flying overhead? Is it feasible for that pilot to accept the surrender of an individual on the ground? Now, these questions that are related to the apparently simple act of surrender highlight how technology has complicated the application of the law of armed conflict. And this can be seen in other contexts as well. There's another example from the Ukraine conflict that deals with the use of smartphone technology. And like Mimi talked a little bit about the use of phones and apps to accomplish things on the battlefield. In this particular case, a cell phone app is used to provide information about incoming missiles and other airborne threats. Ukraine developed the app that allowed users to select from a menu of options. So they could select aircraft, they could select helicopter, they could select drone. And then once they've selected this option, they could point the phone at the incoming object and then press a button. When they press the button, the information would be sent to neighboring Ukrainian air defense units. And that information would include GPS information, and it would include compass information from the phone. Those air defense units could then use that information to supplement their targeting radars and potentially neutralize the airborne threat. Use of the app, however, raises a question of, under the law of direct participation, again, something like Mini mentioned. Under the law of armed conflict, civilians obviously are protected from direct or indiscriminate attack. The commentary to Additional Protocol 1, where this protection is reiterated, states this, and I'll read from the commentary. It says, Article 51 is one of the most important articles in the protocol. It explicitly confirms the customary rule that innocent civilians must be kept outside hostilities as far as possible and enjoy general protection against danger arising from hostilities. Article 51, however, further states that civilians enjoy protection from attack, and this is from Article 51, unless and for such time as they take a direct part in hostilities. So, is a civilian who uses this app, this identification app, taking a direct part in hostilities? Again, this touches on an issue that Lakmini mentioned. This is the civilianization of armed conflict. If a civilian takes a direct part in hostilities, that civilian loses his or her protection from attack and may be lawfully targeted. But DPHing, direct participation in hostilities, raises other questions as well, such as when does the period of DPH begin and when does the period of DPH end? Again, loss of civilian protection applies only for the period of the direct participation. Does this begin when the civilian downloads the app? Does it begin when the app is actually opened? Does the participation begin when the app is actually used? And then on the other end, when does the direct participation end? Does it end once the report is made and the information is sent to the neighboring air defense units? Does it end when the app is closed? Or does it end when the app is actually deleted from an individual smartphone? Again, here we see the use of technology testing the limits of the law. But again, ultimately, I think the existing law seems capable of addressing these questions. On the other hand, there are some emerging technologies such as AI and autonomous weapons that might require a more focused consideration of the law. This is more of Afonso's area of expertise, so I'm going to leave it up to him if he wants to address that. And again, I know we wanted to reserve time at the end for questions, so I'll leave my remarks there. Thank you.
Thanks. As someone who can not even connect to the Wi-Fi network here, I'm feeling like a complete Luddite when it comes to some of the technological issues here. And we're going to come back to Afonso in a moment to talk a little bit more about some of the technological advances and challenges in IHL. But I want to turn really quickly now to another very specific topic in IHL or in armed conflict, and the use of, or the challenges related to the environment and to water. So Tadesse, if I can turn next to you, multiple reports have surfaced concerning the weaponization of water in armed conflict. So how would you say that the weaponization of water has impacted the civilian populations and infrastructure in particularly?
Okay. Thank you, Catherine, and thank you, organizers, for inviting me to this panel. I would say, yes, my topic is very specific, and it's about weaponization of water. And this phenomenon has been one of the very serious issues that contemporary armed conflicts are facing, particularly in urban setting and in protracted conflicts. Water infrastructure and wastewater treatment plants often get damaged or destroyed or purposely sometimes attacked. And those have serious consequences for civilians. And I will begin by giving you some few examples. The first example is in the prolonged conflict in Syria, 2/3 of the total water infrastructure and water treatment plants have been damaged, and that has exposed 12 million people to lack of access to basic drinking water and sanitation. The other example I could, and this report has been put into the United Nations Secretary General's report on the protection of civilians. The other example I have is what is happening in Burkina Faso. So the rebel groups attacked close to 58 water points or water wells where people fetch water. and that has exposed close to 800,000 people to lack of water. In Libya too, in one single instance where armed groups controlled a water distribution facility for a few weeks, like 3 or 4 weeks, that specific single incident deprived the total population in Tripoli, 2 million people, out of water supply. So, and of course, I could mention the current most recent conflict is in Ukraine, armed conflict in Ukraine and in Gaza, where water has been a victim, water infrastructure has been a victim, and they have also been used as a weapon, maybe flooding areas to block the advance of enemy soldiers, etc. So these are the direct consequences or impacts of weaponizing water. What is more delicate and more complex is the indirect impact of water, and which might even test the limit of the law as well. By indirect impact or by reverberating impact of attacking water infrastructure or wastewater treatment plants, it will lead into maybe malnutrition, it will lead into health implication, it will lead into the breakout of waterborne disease, and all this, including environmental degradation and all that. So the question now is, how will IHL address those elements of indirect impacts of attacks? And we could also ask, will the military be considering those indirect impacts, sometimes referred as remote risks, in their assessment of proportionality, or maybe even in taking precautions in attack? So these are some of the challenges, but obviously attacking or weaponizing water has both direct and indirect impact, and the indirect impact might even test the limit of the law.
I mean, I was in Burkina Faso just a few months ago, and of course, one of the impacts of attacks on water sources is that people then have to move in order to find additional water sources. So there are additional impacts, large scale and very, very concrete personal impacts of attacks on water sources. So you briefly mentioned, what can IHL do? So what does IHL say to protect water and other resources during the conflict?
Okay, thank you. There are interesting legal protections. We have different layers of legal protection under IHL as well as under other branches of international law, providing protection for water. So the basic one is general protection that we have under conduct of hostility rules. So water infrastructure are basically civilian objects by nature. So as a civilian object by nature, they cannot be directly attacked. So that's the principle of distinction. And this principle also prohibits indiscriminate attack of objects. This also protects water infrastructure, water treatment plants, and water resources as well. IHL, under conduct of hostility rules, as I briefly mentioned, also has the principle of proportionality. Even when water facilities or water treatment plants are not directly targeted, they might be incidentally damaged or or destroyed. In those cases, what proportionality principle provides is whenever the attack that you are conducting against military objective is going to cause expected to cause excessive collateral damage, even if you will have direct and concrete military advantage, you cannot pursue with what you have planned. You can't execute that operation. What that means is then, does this expected collateral damage include also the consequences or the direct impacts I briefly mentioned, displacement, waterborne diseases, and epidemic or environmental degradation? Should we expect militaries to consider those all factors in the assessment of proportionality when they launch their operation? Beyond that, there is also another layer of complexity, which is how do we consider the cumulative impacts of attacks? So in separate military attacks or in specific military operations, you could strictly follow the limits of the law. However, the moment that accumulates in a prolonged conflict, it will definitely create a bigger challenge. And whether we have to consider or whether the military has the militaries have to consider those cumulative impacts has been a bit a delicate issue. But of course, under Article 51, which includes the provision on proportionality, and Article 57, which talks about precautions in attack, we have expression of military operations. It doesn't specify, they often talk about attacks when we assess the conduct of hostility rules. Then we ask, should we also consider a broader military operation? And of course, Article 57 is clear saying, whenever you conduct a military operation, you have to take constant precaution. Does that taking constant precaution include considering those cumulative impacts that we have caused through repeated or continuous attack or impacts on civilian or water, civilian infrastructure or water facilities? And these are the questions that need to be asked. And for some authors in doctrines, and of course with ICRC as well, those reverberating impacts or indirect impacts must be factored in proportionality and of course in precaution against in attack. However, this is not always accepted by most countries.
Maybe in the interest of time, can you give us one practical recommendation that states can and other stakeholders can use to better protect water infrastructure during armed conflict?
Okay, if it is in the interest of time, I would say one of the challenges basically is implementation of IHL rules. We have diverse set of rules. We have specific protection for water as an object indispensable for civilian population. We have different rules under international human rights law, environmental law, but then the challenge is how do we implement them on the ground? So implementation, and then whenever there is violation, enforcement has been missing. So at least the states need to make sure, need to take the obligation under Common Article 1 seriously. And of course, somehow we have to also broaden the interpretation of some of the rules to make it a living instrument, I would say.
Thank you. So now moving from the super hyper local to zooming not just a 30,000 foot, let's say 300,000 foot level, over to Afonso. Thinking now about the future of IHL, particularly autonomous weapon systems, what would you say are, what are the legal provisions that already do or should govern the development and use of autonomous weapon systems? And specifically, what does IHL demand from users of autonomous weapon systems to perform and satisfy IHL obligations, whether we're talking about states or an individual or maybe both? And then finally, what are the type and degree of human-machine interactions or algorithms are required for IHL compliance?
Right.
And I'm sorry, you have like 7 minutes to answer all of those questions, so good luck.
Thank you. So first of all, I want to thank Jessica Peak for inviting me, lost soul in St. Louis, to talk about these topics. And I wonder if you know how difficult it is to speak after a military person, then ICRC. Well, if tomorrow I'm sacked, you'll probably know why. All right, so let's talk about autonomous weapon systems. I think I saw Professor Sassoli outside, and it came to my mind that in 2014, he wrote an article about the challenges of AWS for international humanitarian law. And what is the challenge of that article is that after 10 years, we still are discussing the same problems that Professor Sassoli raised in that article. And then when I was writing my book, I tried to answer to some of those problems. And one of them is what I call dissociation of communication. And here we had the ICRC say, I have so many questions, oh good Lord. But so a first problem is that when we talk about dissociation of communication on autonomous weapon systems, we talk immediately about meaningful human control. And that is a big question. But we are forgetting another level of dissociation of communication that, in my understanding, has a tremendous impact on IHL and how IHL is going to govern these systems. Is that lawyers do not understand what roboticists are saying, and roboticists don't understand the philosophical questions. To put people from these three different worlds together to discover what is an autonomous weapons system is already a nightmare. And after these 10 years, we don't have even an accepted definition by any state. And if you look to the new draft articles that Canada, United States, Australia, South Korea, Japan have introduced last year at the CCW about the requirements for AWS, if you read the document carefully, is full of incoherences. Because some parts are written by roboticists, other parts are written by lawyers, and the third part we need to guess. So this is just to talk about the chaos of communication when we talk about new technologies. And if we don't know what we are regulating, how are we going to say if IHL is applicable or not? And here states are not helping. For instance, the United States, until very recently, has the opinion that there is no need for definition, for example. We had the United Kingdom in 2011 qualifying an autonomous weapons system as a system with the same level of intentionality as a human being. So see, they changed their position, but just to see the chaos of language that we find. So the first problem, and then, for instance, we have these machines will make decisions. Are we talking about new agents on the battlefield? Are autonomous systems actually taking decisions on the battlefield? Are they moral agents? No, because they cannot be responsible, so they are not taking decisions, for instance, for a lawyer. For a roboticist, they are taking decisions. For a philosopher, he puts question marks. So, this is the first problem, dissociation of communication and when we are going to get the concepts right. And every time that I approach a roboticist saying that I was a PhD candidate, they wouldn't receive me. And one professor explained me why. Because you come here to say that what I do is wrong. I said, that is a poor perspective of a lawyer. No, you say that I can't do that. I said, no, do you want to be responsible for everything that you create in your lab? Of course not. So that is why you need a lawyer. So roboticists now are my friends. Now, the second problem is that I think is how IHL is compatible with a technical problem as AWS. First of all, I think that is up to engineers and roboticists to prove that long-standing principles of IHL, namely Use-Coggins principles as the principle of distinction, will be respected when these systems are activated and deployed. If we look to the recent conflict in Ukraine and also in Gaza, we can see even the Minister of Defense of Israel qualified this recent war as the first AI war. Is debatable, but let's accept it by now. And we see the level of accuracy of data that the Israeli army has access to. Now, we can think that the principle of distinction with these weapons will be more respected in the sense that the level of data, the way the data is processed, we can have access to more quality of data and then preventing collateral damage. But I'm tackling another problem, is that states, if you have noticed for people that enjoy this topic, states are slightly diverging in their position, not to accept autonomous weapon systems, but to defend supervised autonomous systems, meaning that before the system engage time. God.
Finish the thought, because I have a follow-up question.
Right. So just to finish, states want systems that before lethal force is deployed, there is a military commander that confirms or rejects what the system is giving to the military commander. Now, this raises lots of issues. And I think that we are watching to the last moments of proportionality as we know today. because the military advantage will be assessed by the system. The military commander will be confronted with the data of the system, which he won't be able to control or have access to due to the nature of the algorithms involved, and he will assess only if the military advantage compensates or is not excessive to the collateral damage. And that is, I think, we are killing softly proportionality as we know proportionality until today. I had a third point, which is accountability. Should I?
I'm going to ask you about that.
Right, good. So my third point is a rule that we...
I'm going to ask you.
Thank you. So my third point is... Oh, you're going to ask me? I'm sorry. Sorry, I get too excited.
It's okay, but I'm thrilled to hear that our new best friends are the roboticists. That's excellent news.
Yes.
Hopefully we'll have a few of them in next year's ASIL annual meeting. But looking at what you're saying about accountability, the data that these weapon systems are gathering from all over the world, a lot of this data is obviously dependent upon the satellites, which are based in outer space. So would you say that is space the new battlefield? Will IHL apply in outer space? And then what are the accountability requirements for the private owners of these satellites, such as Starlink or some others, during armed conflicts?
Right.
And you have about 2 minutes because we all want to let the audience ask a few questions.
I
too.
will obey. So 2 minutes. So first of all, I think there is no question that the outer space will be the future battlefield. Since 2019, NATO has clarified any doubts that we might have. That is a new domain of warfare. And if we look also to the decision, especially to the United States, because it's more open about these matters, that in the defense strategy also in 2022 declared the outer space as a new space for warfare. And I think even if we look to the Magna Carta or the 1967 Outer Space Treaty, we know for sure that the treaty does not prevent an armed conflict to exist on the outer space. Now, talking about satellites, so it's amazing in my recent research on outer space how we depend on satellites without realizing. So everything we do, from mobiles, for computers, for GPS, whatever we do, depends on satellites. Now, we have this problem that Chrissy was trying to raise, is of the commercial satellites. So we have the United States, pretty much alone in this area because Russia and China operate in different and mysterious ways. So we have the United States having two kinds of satellites, receiving information like Starlink is giving to the Ukrainian armed forces, so is a civilian object that in somehow is contributing for the military advantage of a party to a conflict. And then we have the second part where the United States is investing massively is in double use satellites. So satellites that provide private and civil information, but also military information. So we have two different situations in terms of IHL. We have one that is a civilian object because of its use becomes a military objective, and we have the rules of proportionality to apply. The other case is a dual use object and will raise other problems in terms of precaution, especially about negative or passive precautions. To end up, because my 2 minutes are ending, I wonder how proportionality will be assessed in outer space, for example. We heard ICRC saying that is a problem of compliance. I really don't know how compliance with the rule of proportionality will be possible in outer space. When we have a military advantage, on the other hand, we can have the entire universe without light, electricity, and so on. And then, secondly, the problem of accountability of regarding this the responsibility of states that, the Nuclear Weapons Advisory Opinion in paragraph 84 was very clear to ascertain the responsibility of state for any weapons of the past, present, and future. But how are the states complying with the rules of precaution, not only Article 57, but especially Article 58 in the rule of distinguishing civilian objects from military purposes? And this opens the debate for jurisprudence and for academic work. But I will say that is a big question mark, the question of accountability in outer space. Thank you so much.
And I'm sure the topic for many PhD studies in the future.
Yes.
So we have about 10 minutes for questions with the audience, and I do repeat the word questions. So you are welcome to ask a question, not a statement. There are microphones located in the center aisle. Looks like we've already got someone lined up, and if you would like to join the queue, we'll take a couple questions at a time just to make sure that we have enough time for our panelists to be able to respond. So, sir, please go ahead.
Hi, I'm Nicholas Rostow. I have both some remarks and some questions.
Only questions, please. We don't have time for statements.
Fine, but to remind people, the United States is not a party to the additional protocols, and therefore what it regards as customary international law is rather limited with respect to those protocols, and certain things that the good colonel talked about were policy positions set forth in the DoD Law of War Manual. Now, I have a question for the representative of the ICRC, who talked about non-state actors as if they were entitled to the combatant privilege. And is that what she intended? And to the professor from St. Louis University, the question is, would you regard, well, first of all, how many people in this room are aware that every app on your cell phone is based on open source and open code operating systems which are penetrated by Russia, China, et cetera, and manipulated, and therefore they're completely insecure? And so my question for the professor from St. Louis University is, with regard to autonomous weapons or high-tech, really high-tech, but internet-connected weapons, where the operating system would be vulnerable to attack, would you regard as an armed attack, a cyber attack, an attempt to manipulate the operating system of an autonomous weapon?
Thank you. We'll take the next question.
Good evening. I'm Skylar Reed. I'm a law student. I'm a 1L, so forgive me if this question's a little elementary. But my question is what protections and legal instruments are in place in IHL for rebuilding after a really poor crisis? Like, I'm thinking of Palestine and rebuilding, and how far back does that go? Like, if it would go as far back to like 1948, and considering what happened then in rebuilding, just what protections are in place for rebuilding after a humanitarian crisis.
Thank you. We'll take the next two, and then we'll let our panelists answer the questions.
Hi, my name is Rose. I'm an LLM student from Columbia Law School, and I'm writing my dissertation on slow violence and proportionality. And I wanted to ask Tades's question to Lakimi because I'm doing research on the proportionality calculation, which essentially says that military advantages can be seen in the longer term, while civilian harm has to be seen in the shorter term. So do you think it is possible for proportionality as it stands now to address issues of slow violence?
Great, thanks. Last question.
Yeah, so hi, I'm Agnieszka Starczewska, and I'm also a student, but a PhD one. So I wanted to actually ask, because at the beginning it was said about the principle of distinction and between the military targets and non-military targets. So I wanted to ask, how would you place the international investment in that whether they are military or non-military, as sometimes, as we all know, they can be, for example, factories of some sort that is actually relevant to the military business. So yeah, so that's my question. Thank you.
Thank you. So we've got about 1 to 2 minutes for each of you to respond to any of the questions that were asked. So Ron, maybe I'll start with you.
To Nick Rostov, excuse me, thank you for that clarification. Yes, the United States is not a member of Additional Protocol 1 or hasn't signed on to Additional Protocol 1. As a matter of policy, you'll note that I was referring back to the DoD Law of War Manual rather than back to Additional Protocol 1 itself. The United States does consider certain provisions of the protocol to be customary international law, but obviously not all of it, otherwise it would have signed up to Additional Protocol 1. So thank you for the clarification. And it is important, and I think this sort of gets to the remarks that I started off talking about, which is understanding what the legal requirements are and understanding what the policy overlay is, or why we follow certain things. Do we follow it because we believe it is the law or it is the law? Or do we follow it as a matter of policy? And again, I think there's going to be a great panel tomorrow, again, 0900, talking about civilian harm mitigation and response. And you'll see that dynamic. Does following something as a matter of policy eventually ripen into a legal obligation? Is that a danger? So these are some of the questions I think tomorrow's panel will address.
Ragmini.
To the next question, the short answer is no. It's not about combatant privilege. What I meant is that non-state actors, going back to the principle of reciprocity, non-state actors also have obligations under the law, and the law is clear about not granting legal status, but there are certain, if you look at Common Article 3, for example, there's clear language from which you can deduce that there's possibility for non-state actors to detain. There's responsibilities in how to treat those affected by armed conflict and so on and so forth. So the short answer is no. So I'm glad you gave me the opportunity to clarify. And on the question of proportionality and how the ICRC would look at the interpretation of that, very succinctly speaking, I think for us, the important, in whatever shape or form the ICRC has spoken about proportionality, whether it's in terms of reverberating effects, whether it's in terms of urban warfare, in terms of protecting the environment, and so on and so forth, our position has been to look at, to think through the prism of foreseeability and to look at it as foreseeable consequences. So the more we advance in technologies, or and not necessarily in terms of means and methods, in terms of scientific developments, that foreseeability becomes even more a possibility, and therefore looking at consequences for civilians even more a predictable and foreseeable consequence. So I would say in relation to that, and may I take 30 seconds just to react to what Ron said about law versus policy. I would definitely advocate for the panel tomorrow as well. And there, I think, for us, again, something that the ICRC would look at is, yes, definitely there's a difference between law and policy, but sometimes policy, the underpinnings of a policy is a legal obligation. So not to confuse and sort of trivialize the legal obligation by way of a policy is an important one to remember. And maybe the last thought, because I am the representative of the ICRC in this panel, I think a very important message that the ICRC would put forward as we approach the 35th anniversary of the Geneva Conventions is to look at new developments in the law as building up on fundamentals and not questioning the fundamentals, and to go back to the objective and purpose as we develop the law in tandem with developments in military evolution, and to go back to the obligation of compliance and to sort of take on the responsibility as parties to conflict, and also look at Common Article 1, which talks about ensure respect, right? So it's not just about the parties, it's also about those who influence the parties. And finally, not to encourage narratives that are harmful about IHL being fit for purpose, because that doesn't serve a purpose. We have agreed on the fundamentals, there's a reason why the law is there, and there should not be exceptions to an exceptional body of law, because the IHL is the exception. So I would say those are three important things that ICRC would emphasize on.
I don't even have to give a sum up at the end of this panel because you've done such a brilliant job. 1 minute each, maybe for Afonso and Tadesse.
So regarding the, if I understood the question correctly, so the possibility of a cyber attack against an autonomous weapon system. So I think if it could be qualified as an armed attack. So I think it's very important to make a distinction which branch of international law we are applying here. So if we are talking about an attack against an autonomous weapon system, if can be compared with an armed attack, we are under jus ad bellum, and we apply strictly questions of sovereignty and the test effect that the Tallinn manual complies in Article 70, I presume, if I'm not mistaken. And so we would, if that attack could be compared to an armed attack, and with all the problems that what can be an armed attack. In the context of using bells, so in the context of an armed conflict, if there is a cyber attack against an autonomous weapon system, the question it is an attack under Article 49 as any other attack. It needs to obey the rules of proportionality and distinction and so on. But if it is an autonomous weapon system, it's clear that it's a military objective, so the attack is absolutely legitimate.
Thank you. Very last thought from Tides.
Yeah, maybe a brief reflection on the post-conflict reconstruction. Under IHL, we have one provision under AP1, which talks about responsibility of a state that violates IHL rules to make possible compensation. But that is really about violations. So in case you conduct military operation and you destroy collateral damage is not disproportionate, you might not be asked to pay compensation for that. And there were practices actually in post-conflict reconstruction. For instance, during the Iraq acute conflict, the invasion, the UN Compensation Commission was established, and that had helped a lot. And of course, post-conflict reconstruction has always been a political process, and the UN also has a commission, a peace-building commission that usually contributes to help states coming out of conflict to rebuild their infrastructure.
Thank you. So thank you so much to all of our panelists for this amazing discussion. I don't think I've had more fun on a panel in a very long time. So thank you for a robust and wonderful discussion. I've also been asked by the ASIL team if you have signed up for CLE credit for this session. Remember, you are in the Geneva Conventions at 75 in the future of IHL. So if you have signed up for CLE credit, your code word is PARROT, P-A-R-R-O-T. Thank you again to our panelists. Thank you all. And hopefully we'll see you at the 9 o'clock session tomorrow.